On March 23, 2010, the Patient Protection and Affordable Care Act was signed into law. Prior to this act, various programs sought to provide healthcare coverage and access to low-income adults, children, and elderly populations, but our system was failing millions of non-elderly citizens. The PPACA was implemented with the goal of reducing the number of uninsured Americans, cutting healthcare costs, and holding insurance companies more accountable. To do this, the PPACA sought to expand current programs and implement provisions to the healthcare system. One of the programs extended was Medicaid. The expansion provided coverage for those below 133% of the federal poverty level, as well as subsidies for those who do not have access to employer-based coverage, with incomes between 133 to 400% of the federal poverty level. Over half of the states and private parties filed lawsuits because they believed this provision was unconstitutional. In the Supreme Court case National Federation of Independent Business v. Sebelius, the Supreme Court ruled that it was unconstitutional to force states to expand their Medicaid programs and that they would have to have a choice to expand without the risk of losing current funding. About half the states opted out of expansion. Implementation issues that have and will continue to arise create an unbalanced, inequitable system. Although Medicaid expansion is ensuring millions who were previously uninsured, increased coverage and access to care creates problems. California alone is expected to have an increase in over 1 million patient visits annually. Providing quality, efficient care will be a challenge. This will also strain our system in terms of cost containment. Federal funding for Medicaid will decrease by the year 2020 from 100% to 90% and may continue to descend. To assume greater financial risk for Medicaid patients, many healthcare providers now collaborate in accountable care organizations, or ACOs. The goal was to reform the provider payment and delivery systems and provide more equal quality care while managing costs more effectively. Whether this long-term goal is met is still uncertain. Not only is the establishment of ACOs uneven across the U.S., but there is also no guarantee that costs will be controlled. Concerns arise over ACOs potentially ruining the competitive healthcare marketplace and unfairly raising prices, which violates the antitrust laws. ACO success also depends on providers' aptitude for retaining patients within these new collaborations. In turn, concerns arise regarding providers' financial incentives and violating the anti-kickback law. Other provisions sought to build on the employer-based health insurance system. One provision requires employers' healthcare plans to extend coverage to young adults within the family up to age 26 to ensure almost 15 million uninsured individuals between ages 15 to 29. To further expand employer-based insurance, the employer mandate requires that businesses with 50 or more workers offer employers health insurance or else pay thousands of dollars in fines per employee. However, studies indicate that hundreds of thousands of people will not have coverage this year due to over 1,000 large employers delaying coverage. Despite penalties being enforced, many workers have been left behind to fend for themselves in the health insurance marketplace. Many people are forced to seek insurance through the new affordable insurance exchanges instead. Affordable insurance exchanges are available at the state level for employees to buy subsidized insurance if their employer does not provide an affordable option. Covered California is California's insurance exchange through which many Americans can obtain coverage. The exchanges enable citizens to obtain health insurance who otherwise would not have been able to afford coverage. Exchange plans must offer the minimum essential health benefits, including services for emergency, mental health, substance abuse, rehabilitation, lab work, pediatrics, preventative health, chronic disease management, hospitalization, maternity care, and prescription drug coverage. This requirement ensures Americans' right to access at least a basic level of health care. The exchange programs must have risk adjustment and reinsurance programs as well as risk corridors. Risk adjustment programs prohibit insurance companies from selecting healthy enrollees over enrollees with pre-existing illnesses as they often did before the PPACA. These programs intend to keep costs down while insuring more people by transferring funds from plans with low-risk enrollees to plans with high-risk enrollees. Reinsurance programs intend to keep premium expenses under control in the next few years. Both reinsurance programs and risk corridor programs act as safety nets for insurers who are covering expensive healthcare patients. Insurers receive payments for expenses that exceed their maximum target amount so that they don't face major financial losses. Most importantly, these provisions aim to counteract adverse selection in the health insurance marketplace. Beyond these programs, the medical loss ratio provision ensures that patients get the appropriate amount of care required and that premium dollars are not being excessively spent on administrative costs. Insurance firms must spend at least 80 to 85% of patients' premium dollars on medical care or else issue rebates to consumers. Some states have filed waivers from compliance with medical loss ratio standards, which is not surprising as many facets of the PPACA have been controversial and challenging to implement. Probably the most controversial provision, the individual mandate, legally requires citizens to get health insurance if they can afford it or otherwise pay a penalty of either $95 or 1% of their income. In the Supreme Court case National Federation of Independent Business v. Sebelius, the court upheld the constitutionality of the penalization as long as it was characterized as a tax. This provision was made to shift the cost of caring for the uninsured on those who chose not to obtain insurance. This also acts as an incentive for citizens to buy insurance, thus increasing the number of people with coverage. A critical group of people who have been able to gain coverage under the ACA include those with pre-existing health conditions. Under this provision, insurers could no longer deny coverage to these individuals, nor could they continue to set their premiums extremely high. Still, while millions of people are gaining coverage under the PPACA, about 26 million will not have coverage by 2016. This group consists of undocumented immigrants as well as those who would rather pay penalty than purchase insurance. Furthermore, the constitutionality of some provisions, such as the individual mandate, has been challenged based on American ideologies of freedom of choice and individualism and disapproval of the government's power under the Act. More recent issues have occurred regarding interpretation of the ACA in legal cases. Handbook v. Burwell challenged the legality of subsidies provided to citizens in states that did not set up their own exchanges. The IRS interpreted the ACA and stated that subsidies would be provided for insurance that was purchased in both the federal and state exchanges. Handbook claimed that the ACA does not state that tax credits can be given to individuals who purchased insurance through a federal exchange. The Court of Appeals in the D.C. Circuit ruled in favor of Handbook, concluding that the ACA states that subsidies would be provided only to state-run exchanges. On the same day, the Fourth Circuit ruled in favor of Burwell in the case King v. Burwell, creating a conflict of opinion in the appellate courts. Moving forward, the Supreme Court can decide to take the case and make a universal ruling, or there will just remain a difference of opinion in the two districts. What this means for the ACA is that many people could lose their subsidies in states without exchanges, which could discourage people from keeping or obtaining insurance. Another mandate that has been challenged is the contraception mandate, which requires that employers offer FDA-approved contraceptives in their health insurance plans. Hobby Lobby, a for-profit employer, felt that this mandate violated their religious freedom and they chose to sue for the right to deny employees coverage for certain contraceptives. Hobby Lobby argued that their rights were protected under the Religious Freedom Restoration Act, which prohibits the government from enforcing a law if it interferes with the religious beliefs of a person. The 10th Circuit Court ruled in favor of Hobby Lobby, stating that Hobby Lobby is considered a person and that the mandate violated the Religious Freedom Restoration Act. With this ruling, there is now a precedent set for future cases that could encourage more employers to request that they too be exempt from mandates of the PPACA. Legislative enactments address discrimination and harassment in the U.S. healthcare system. Title VI of the Civil Rights Act of 1964 prohibits discrimination in companies who are given federal financial assistance based on a person's race, color, or national origin. In the healthcare setting, this pertains to hospitals that are reimbursed for Medicare and Medicaid. Title VII forbids discrimination and all forms of harassment in employment-based actions on the grounds of race, color, religion, sex, national origin, or pregnancy. This includes prohibition of creating harassing environments. Section 1981 of the Civil Rights Act of 1870 guarantees citizens have equal rights under the law and protects against forms of employment discrimination based on race, specifically ethnic subgroups. For example, a hospital cannot legally discharge a patient based on racial motivation. Under Section 1981, people can also make and execute contracts. Section 1983 of the Civil Rights Act of 1871 protects against deprivation of individuals' constitutional rights under color of state law. Healthcare facilities must provide due process prior to making employment decisions. Finally, Section 1985 of the Civil Rights Act of 1861 prohibits conspiracies from interfering with civil rights. Civil rights laws are critical in considering the appropriateness of healthcare environments and the relationships within these environments.